Hey guys, this is John Watts. Welcome to this video. I'm a consumer protection lawyer and I want to talk with you about something that is probably not the most exciting subject, but if you're going to be fighting with debt collectors, if you're going to be in a lawsuit, this is really, really vital. And that is understanding the rules. Well, what do I mean by the rules? For example, the rules of civil procedure, the rules of evidence. Okay, but let's just go with the rules of civil procedure. And and let me give you an example. So I was having a recent conversation with a lawyer, and we were talking about a case that was filed and whether something was a dismissal with prejudice or without prejudice. Now, why does that matter? Well, and you have to check your state, but in most states, and certainly in my state, a dismissal with prejudice is what's called an adjudication on the merits. Okay, it means it's been decided in your favor. Okay, without prejudice, it's like the lawsuit was never filed. Well, this, you can imagine, becomes very important if maybe you've been sued by a debt collector and you get a dismissal. Well, if it's without prejudice, it doesn't really mean anything. They can sue you again. If it's with prejudice, they cannot sue you again. And they may have to come off the credit reports, and there's all sorts of implications from it. But just understanding that rule, is it with prejudice or without prejudice, gives you a real advantage. Okay, and like I give you another example. So this is something, we've had this conversation a dozen times where we get sued by a debt collector, we win, we then dispute it with the credit bureaus, it doesn't come off, and we sue. Okay, and the debt buyer, the lawyer representing the debt buyer who we've sued, will come to us and say, you know what, John, your client really owes that debt, and we're going to prove it in this case that you filed. I said, really? You're going to prove it? They're, oh, yeah. We'll prove we bought the debt. We'll put in the purchase agreement. We'll have people testify from the original creditor, and we're going to show that jury that your client owed that debt. You just got lucky at small claims court or district court or circuit court, wherever we sued you. And I go, really? And so what does that mean to you? And they go, so that means you're not going to get any money. So we're not going to really offer you. We'll offer you, like 5 or 10 grand for this thing. That's it. There you go. And that's all based on the fact that you're going to prove in my trial where I've sued the debt buyer that really we owed the debt. They go, yeah. They go, actually, you're not. See, that train left the station when you lost your case against my client. You don't get to come into court and say, well, yeah, we really own the debt, and John, your client really owed it. That's gone, okay? That's been decided in this earlier court in our favor. So you don't get to come into, for example, federal court where the case is pending now and say, yeah, we know we lost over here, but really we want to, do it the right way. Now, you don't get to do that. And so, some of these are sort of esoteric things. There's stuff called res judicata and collateral estoppel and issue preclusion and claim preclusion, all these different things. And if you're not a lawyer, I'm not saying you got to learn all that. For the lawyers watching that, yeah, you need to know all this stuff. But if you're handling a case on your own, know your rules, okay? So give you an example. In Alabama, we have 3 levels of courts. We have small claims, district court, circuit court. Small claims and district court are really the same. It's the same judge, but there are slightly different rules for small claims court. And so we literally have the small claims rules. But then we also have the normal Alabama rules of civil procedure. You have to know, where do these things overlap? Where do they conflict? When they conflict, you go with the small claims court rules. And just understand what's the right or the ability of the debt collector to do something. So, we've had this a lot where we're in small claims court and the debt collector the lawyer for the debt collector, debt buyer will say, well, John, before you got involved, we served request for admissions, that's discovery, on your client, and they didn't answer them. I'm like, so what? They're like, well, now they admitted we own the debt and they owe it. I'm like, no, discovery's forbidden in small claims court. They're like, no, I don't think so. I'm like, read the rule. You'll know. Now, I say this is true in Alabama. It may not be true in your state, in Georgia or Mississippi or wherever you are. But the point is, know your rules. This is like being in the Super Bowl. and trying to figure out now, if I'm catching a ball, do I have to have both feet in bounds, or is it just one? Or is that college? Or what does a shot clock mean in basketball? Or can I call a timeout when I don't have a timeout in basketball? Or what happens in boxing, if I get knocked down or my opponent gets knocked down? My point is, you've got to know the rules. If you are representing yourself, you've got to put the time in to know what are the rules of the game, okay? Which starting off would be the rules of civil procedure. And then kind of the next level would be rules of evidence. Not that you have to learn everything. And we've talked about some of these here, the best evidence rule, the completeness doctrine, things like that. Hearsay. And I probably need to finish that because I don't think I finished it on hearsay. But, you've got to figure out what is important for you in your particular court, in your state. And then you've got to master that. I mean, I'll say this, and I don't say this, egotistical way. But when I first became a lawyer, and I learned this from a guy in law school who spent all of his time in federal court, and he said, John, if you will know the rules of civil procedure better than anybody in the case, it gives you an unfair advantage. And I said, hey, I want an unfair advantage, okay? And so that was my goal. I never wanted any lawyer on the other side to know the rules of procedure better, the rules of evidence, how we try a case, the theory. If I'm suing under the Fair Credit Reporting Act, no lawyer on the other side should ever be remotely as skilled in that law as me. Fair Debt Collection Practices Act, negligence, wantonness, wrongful debt, whatever it is. I always said, you know what? I've got to get that. Now, it may mean I stay up late and I read this stuff. I learn it. I immerse myself in it. And my suggestion is, if you're handling your own case, you need to have that same attitude. And look, some people say, I'm just not going to spend the time. Okay. My suggestion is spend money then. Hire a lawyer or settle it, whatever you're going to do. But if you want to be as successful as possible, there's just no shortcut for putting in the work, knowing what the rules of your court, your state, the rules of civil procedure, rules of evidence, the theory that they're suing you under. So they sue you under breach of contract? Well, what is a breach of contract in Missouri or, Nevada or Alabama? What's an open account? What's an account stated? What's unjust enrichment? Whatever the theories are they're suing you, do you know that? Because sometimes you can point out that these are contradictory. Like, for example, open account and breach of contract, those would be kind of contradictory. Okay, if we have breach of contract, we don't have open account. If we have open account, we don't have breach of contract. And so to be able to argue that and point that out to the judge so that when you're standing there, the judge says, wow, you're organized, you're on time, you know what you're doing, and you know this better than your opponent. And then what happens is, at some point in a trial, not every trial, but now I'm really talking about jury trials. At some point in a jury trial, there's going to be a legal issue, and the judge is like, I don't know. It's kind of this like toss up, I could go either way. Well, if that judge, if she knows that you know the law better than anybody in that courtroom, and you're honest and you don't make stuff up, you don't hide stuff, then she's going to look to you and say, so what is the law on this? And you say one thing, your opponent says the other, and she goes, yeah, but you know it better. Again, it just gives you an advantage. And you earn that advantage by doing the work, learning the law, learning the rules, learning the procedures, and then going from there. So anyway, I hope that this is helpful, and I will talk to you guys soon. Have a good one. Bye-bye.